Any mention? May I please, Your Lordship? I beg to mention item number 14 and 16. It's connected.
Yes.
Yes, Lordship.
14 and 16.
Yes, Lordship.
In?
I'm for the petition lodged in item number 14.
Oh, yes. Yes. So, what is your prayer?
Let this matter must come after 2 weeks, Lordship, and we will file the objection of the miscase, Lordship.
This case means what?
They filed a miscase, Lordship.
What?
Because there was a miscellaneous case for stay of the proceedings. So,
That is a lokayukta matter.
Yes,
Yes,
Lordship.
yes. Yes, I think this
yes,
the proceeding is suspended.
suspended, my lords. Yes. The interim orders may continue, my lords.
Yes. Yes, Mr. Jindal.
There is also another miscase for Lordship's consideration filed by my friend for impleading the Lokayukta. So I am appearing for the Lokayukta. As far as that miscase is concerned, my lord, there are two miscases. Item 14, my lord, that is miscase 2 of 2024, item 14.
Yes.
And item 16, my lord, it's miscase 3.
Yes.
As far as these miscases for impleadment is concerned, my lord, we leave the issue of impleadment, whether or not to implead us, up to the good judgment of this honorable court. If Lordship is convinced,
You do not have any objection to that. You are not filing any objection.
we are not filing any objection. We leave it up to the.
Anyway, we'll take it up the matter when this
When the
it's
matter
taken up.
comes.
We are not passing any order right now.
Very
If you want, we can just say that you are entering appearance on behalf of.
Lokayukta in miscase so and so.
In miscase 3 of 2024 and
In item 14, my lord, that's miscase 2,
yes,
and item 16, my lord, miscase 3.
in those two miscases, you just say Mr. Jindal has entered appearance on behalf of the
Lokayukta.
opposite party. What do you know? Do you remember? Any on behalf of the Lakayuk. Okay, and then you will say the list it along with these other matters. And the writ petition you say is paid for by. So and so learned counsel appearing for the respondent number so and so. This is matter after 2 weeks.
Lords, if your lordship may consider appropriate.
Interim order. Passed
Interim
earlier,
order.
circular.
Oblige, your lordship.
In both the matters, huh? Yes.
Oblige.
My lord, I beg to mention item 20, my lord. In this matter, my lord, additional affidavits were supposed to be filed. We have filed. It's on board, my lord. We have served a copy to my landed cities, the government also. So, my lord, let this matter come up for hearing after 2 weeks, my lord.
No problem. Yes, that's preferable. Land council for the petition and this is matter after 2 weeks. Yes,
Madam, obliged.
May I please, Your Lordship? I beg to mention item number 9, 10, and 11. These are connected matter, Your
they're
Lordship.
connected matters.
Lordship, yes.
I'm praying for 2 weeks' time, Your Lordship.
Oh, Mr. Sanglisho.
Yes, Your Lordship.
Yes. After 2 weeks. Yes. 19 and 11. At the request of the petitioner, this is matter after 2 weeks.
Oblige, Your Lordship.
May it please your lordship. Lordship, I beg to mention item number 8. Lordship, I'm
Yes.
praying that this matter may come up after 3 weeks, lordship. Having some difficulty. Able to take.
I'm for the applicant, lordship.
You have no objection.
It'll be 2 weeks, lordship.
It's Mr. Criminal Appeal.
Yes, sir.
Yes, sir.
As requested by Mr. J. Thaba, learned GA. Appearing for the respondent and not objected to by the learned counsel, appearing for the appellant. This is matter after 1 week.
Obliged, lordship.
May I please your lordship? I beg to mention item number 15. May this case can come up after 3 weeks, your lordship.
You are mentioning on behalf of
Petitioner, your lordship.
We have no objection.
Ministry. Respect to the learned counsel petition. List of proceedings. Okay. Yes.
Obliged.
Your lordship.
May I please, Your Lordship?
Yes.
I beg to make a mention of item number 5, Lordship. Lordship, I pray this matter may be listed after 2 weeks.
2019 matter. Why? Who is the other side?
No objection, your lordship.
Same order as requested by the petitioner and not objected to by the learned counsel for the respondent. This is matter after 2 weeks. Yes.
Lordship, similar prayer for item number 6.
For the respondent. Okay. No objection. Same order. Yes.
Highly obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 19, Your Lordship. Your Lordship, the conducting counsel, Ms. N.G. Shilla, is indisposed, Your Lordship.
I'm for the petitioner, my lord.
No objection.
No objection.
This is also as requested by the learned counsel. By so and so, learned counsel appearing for the state respondent. This is matter after
2 weeks, Your Lordship.
Obliged.
yes.
Much obliged, Lordship.
May I please, Lord?
Yes.
My lord, item number 12, my lord.
Yes.
My lord, the affidavit is on the board. We have filed the affidavit, my lord. On the last occasion, my lord has directed to verify whether the affidavit has been filed or not. It has been filed, my lord. So, my lord, I am praying that the matter can come next week, my lord.
No objection, Your Lordship.
This is also as requested by so. This is matter after a week. Yes.
Much obliged, Your Lordship.
Highly obliged.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 7. Lordship, I pray for 2 weeks' time in this matter.
No objection, Your Lordship.
So, the request to the petitioner, list after 2 weeks. Yes.
Lordship, similar prayer for item 17.
They are also you are there.
Yes, Your Lordship.
Yes. Same order.
Much obliged.
Daily cause list, item number 1.
May I please, your lordship?
Yes.
Lordship, the petitioner herein is the wife of the complainant, your lordship, who is the respondent number, private respondent number 3 in the instant case, your lordship. The incident complaint, your lordship, was filed by the respondent number 6 against the petitioner, your lordship, alleging that the petitioner has stolen some of the property documents from the dwelling house of the respondent number 6, your lordship. Respondent number 3, your
Petitioner
lordship.
is the wife, and
Yes, your
respondent number
lordship.
3 is the husband.
Yes, your lordship.
Husband has filed a complaint.
Yes,
against
your
you.
lordship. Yes, your lordship.
Yes.
Your lordship, the brief fact is that, your lordship, prior to the FIR filed by the husband, your lordship, there was a complaint filed against the husband by the wife, your lordship, who is the petitioner, your lordship, alleging that there was some kind of physical assault and mental assault that was meted out to her, and those complaints were still pending before the Women Commission, your lordship. So during the pendency of that complaint, your lordship, the respondent number 3, he has filed the complaint alleging that those documents, those land documents were stolen.
Where is the
from his-
complaint? Where is the complaint?
Lordship, Annexure 4 is the FIR, lordship,
Yes.
page number 28, lordship.
What is the annexure 20? The annexure page?
And Annexure 4, lordship, page 28. That is the downloaded copy of the FIR, lordship.
Page 20.
28, lordship.
Lordship, that will find, Lordship, the content of the FIR as page 43, Lordship.
43, lordship.
This is from NCRB, Lordship.
NCRB,
Where is
download.
where is the Jahar? Where is the
Lordship, the content of the FIR, it's there in the
FIR has not been enclosed, Lordship. That is the report they have downloaded or got from the NCRB, Lordship. The content is at 43.
If I may read, lordship, the content of the FIR.
Yes, please.
To the officer in charge, Rongram Police Station, West Garo Hills District, Meghalaya. Subject: the FIR against Srimati Suchorita Marag. Respected sir, with reference to the subject cited above, I have the honor to state that in the month of September 2024, Srimati Suchorita Marag, Suchorita Barua have stolen my land patta, white bearing land patta number 23, dag number 24, patta number 31, dag number 42, patta number 127, dag number so and so, and in my absence. It is stated that at the time when she have forcibly stolen the above mentioned land patta which belongs to me, as I was not at home, and she has stolen the said patta without my knowledge. I came to know about the incident only recently when I tried to find out my land patta to produced in the office. However, later I came to knew that the above mentioned patta had been stolen by above mentioned person, and till date the said documents are being kept illegally in her custody. Therefore, I am filing the incident FIR and requesting your good self to investigate the matter and also to book her under the appropriate section of law, and also to take strong action against her as per the law. Thank you.
Then what happened?
Your Lordship, what exactly has happened was that, Your Lordship, the petitioner was chased away from her house, Your Lordship, by the private respondent number 3 only.
No, anyway,
and she was even
it's all like
threatened.
that you have said already.
Yes, Your Lordship.
There is a case pending under domestic violence.
Yes, Your Lordship. Yes, sir.
No,
So
but
this
in
this FIR, yes, this FIR was the outburst of
discloses-
that complaint only, Your Lordship. And moreover,
how do we know it?
Your Lordship, I have admitted that at the time when I left my residence, Lordship, without my knowledge, I had certain land documents. There are two land documents which is in my name as well and in the name of my
But this
husband.
FIR was
And by
registered.
mistakenly, I had in my possession those land patta, which even I contacted the respondent number 3 that I wanted to return those land patta. But your Lordship would appreciate that I was threatened by respondent number 3 not to come to his residence and not to even come to Tura.
Anyway,
And
now
in
it
the
is
meantime,
now it is
Lordship,
now it is before police. Police will take care.
Your Lordship, I was issued 35(3) notice also, Your Lordship, and
Where
I
is
was asked to comply.
Where is that notice?
Annexure 5, Lordship.
Normally, police will not take you into custody.
But
let the matter be
my
investigated.
only issue is that, Your
Where is
Lordship,
the-
I
where is the
fear
notice?
that 45, Lordship.
Page
45.
45, Lordship.
Page 45.
Yes, Your Lordship.
No, page 45 is the
Notice under 41.
Notice under
Lordship.
35(3).
Now 35(3), Lordship.
Yes.
Lordship, what my fear is that, Your Lordship, I have been threatened because prior to this
When you have
incident,
been asked to appear?
9/12, Lordship.
It's already gone.
But
long back.
Lordship, what has happened is that I fear that if I go and comply with that notice before
No,
Rongram.
It means you did not go there.
No, Your Lordship.
Then what happened?
But I have been called up by the IO to come and appear. But my fear is that, Your Lordship, before that, I had already appeared before Rongram police station with regard to the same.
Notice be issued to the husband,
Just take
Lordship.
instruction.
Yes.
She is the.
You take instruction.
I'll take.
See, like
Yes.
she's a female.
Yes.
So I don't think you need any custodial thing.
No, Lordship.
And if there is a marital
And she can
discord,
appear
then you
also,
should
Lordship.
take notice of that also. Anyway, hard mistress. Issue notice. Returnable in 3 weeks. Mr. Singh, London GA.
1 and 2.
GA or PP? GA.
GL.
The PS for respondent 1 and 2. Stop. Petitioner to take step for service upon respondent number 3 within 2 days. List after 3 weeks.
Master.
Deploy.
Item number 2.
My lord, paper books are ready and we have supplied.
Yes. Yes, Mr. Pandey. What is this?
Mr. Khera, my lords, this is an application for impleadment which has been.
Mr. Khera will be the conducting counsel.
Yes. Who is appearing for the petition or applicant?
Mr. Khera.
Yes. You are not audible, Mr. Khera. You are not audible.
If I may, Your Lordship.
Yes, please.
Your Lordship, this is an application for impleadment.
In
CRP 28 of 24, Your Lordship.
Impleadment in CRP?
Yes, Your Lordship. Actually, the CRP is filed against an impugned order where a work has been stayed, Your Lordship.
Which work has been stayed?
The work is for construction of a substation at Maukan, Your Lordship, of which Power Grid is the implementing agency.
Where is that order?
As admitted, Your Lordship, we don't have the copy of the CRP, Your Lordship, because we are not a party to it as of now.
This, why it is a revision then?
Your Lordship, they have.
If I may explain.
Yes, please.
Lords, Meghalaya Power Distribution Corporation Limited, to whom I am representing, Lords, had preferred a CRP against an order passed by the District Council Court. In the District Council,
District Council passes order against Meghalaya Power Distribution.
Yes, that is the anomaly, Lords.
We are not a party there.
We cannot be a party before the District Council Court. So an inter se dispute between certain.
And then where is that order? The order said what?
Lords, the order injuncts the Meghalaya Power Distribution Corporation to complete its works.
Where is that order?
Lords, it is in the main petition because they have not annexed it in the.
See, that is one thing is that this is a revision under provision.
Lords, this is a 227.
You are not a party.
Yes, 227. We have
227.
Yes.
Now, the proceeding before District Council, you are not a party.
I am not.
Then you have been indicted.
Yes, my lords.
This court is interested to say. Before we make it complicated, why should we make it complicated?
Yes, my lords.
See, normally 227 revision will be maintainable only in cases where court travels beyond the boundary.
Yes, my lords. Yes, my lords.
Which shakes conscience of the court.
Right.
Otherwise, it cannot be a substitute of a regular revision.
Yes, my lords. Yes, my lords.
Yeah,
absolutely.
Now, the surprising is that a revision has been preferred by a third party.
Third party.
Now, what is the law which allows a party to, which allows a third party to file a revision?
Well, my lords,
there is a provision for third party appeal.
Yes, my lords. But here the situation is that the third party has been without, because no hearing could have been granted.
Where is the order passed?
My lords may see Annexure 1 of the CRP 28.
Yes.
So this is at page number 19.
Yes.
As my lord sees that this is between one Mr. Phoenix Minsong and Intriya Minsong.
Yes.
And thereafter.
Who is appearing for those persons, those private parties? See, are they party here in this?
Yes, my lords. In the CRP, they have been made part. They not because only one hearing has happened in this matter where notices were issued.
Whether they have been served or not? Any idea? No idea.
No idea. Whether they have been served, I'll check with my. So, my lords, at the bottom of this page, there is opposite party number 2 is not directed not to disturb the petitioner and the family members during the visit to the suit land, as it would be violation of orders dated 18/3/2020 and 19/2/2021. And similarly, my lord, just sees the paragraph just above it. Therefore, the petitioner has the right to enter into the suit land for cleaning it. The order dated on record 19/2/2021 will also take effect from 2/3/2021. The cleaning drive was obstructed, and thereafter this injunction has been.
Okay, but then where you are not there?
I was not there, my lord.
Then,
and then
which way this order affects you?
That is the point, my lords. OC, next page. The OC of the police station has been directed to enforce this order.
That is all right, but then this order is not concerning you. You are not a party. There is nothing specific that you were injuncted.
Right, my lords. That is absolutely correct.
Yes.
Now this order is being utilized to stop the 95% of the work which has been completed by
them. Who is utilizing this order?
The petitioners, my lords, in the matter. Yes, if
that
that
is the
clarification, I
thing,
believe.
see, filing a revision is not at all maintainable. See, the normal thing is that if in a civil proceeding, if you are not a party,
Right.
any order passed, even including decree, cannot be implemented.
Yes,
That is the law.
yes.
And if you find that somebody is doing that, 227 is not a thing. You see, 227 would come only when district council, as you said earlier, the
Right,
first
right.
impression which this court got from you, had there been an order passed by that court directing you, that this could have been a good ground for interference under 227. But the order doesn't say so. We cannot say
Because
that
the issue
it
here
has
is,
traveled beyond the boundaries prescribed.
if your lordship sees annexure number 2, which is annexed here, which is just subsequent to the order that your lordships read, that is at page 21.
Pandey, this court understands what you are trying to say.
So
this may be a ploy to disturb your functioning.
Yes, my lords.
We can understand, but then 227 is not the answer.
My lords,
see,
the
proceeding before district council is purely between two private parties. You are not a party there.
Right, my lords.
Now, if you find that this proceeding has any bearing, so far as your activity is concerned,
yes,
227 is not the solution.
Because then I may be in a situation where I may not have any remedy.
You will have the remedy. Why not? This court is not supposed to advise you. Why not?
I appreciate
227 is not your remedy here.
Because a proceeding where I am the owner of the land, I am the owner, the sale deed is there.
And you institute it. If you say you are the owner, then you institute appropriate proceeding. This court under 227 will not say that you are the owner.
I may have instituted, but there is an interim order which is operating at this stage.
That you know how to do it. There is a solution in law, not 227. Until and unless there is something specifically to show that order has been passed against you and you have been specifically injuncted. You are trying to, give an interpretation of that, but then there is nothing direct. So long it is not there, why should you interfere?
Even if that clarification comes that there is nothing which affects me, then I will, my works...
That is the law, Mr. Pandey.
That is the law, Mr. Pandey. The situation is this order is being implemented. Even the officials have gone to the police station and the police has not refused to...
You filed proceeding against police. Police cannot act on the
My lord,
if
my lord, if I may,
anyway, this you see, like it
today,
should not be something like that. This court has to spell out what you should.
Because, my lords, on the last occasion, this court, after going through the records, believed that the entire trial court records have to be summoned. As we are not parties to the proceedings,
this court has passed that order.
Yes, my lords, that order has been passed.
My lord, order dated 26/11/2024.
Yes,
the court has taken note of the matter, lordship, and the records were called for, fixing the date on the 3rd of February 2025. However, being a holiday, matter could not have been taken up.
This is not by this court, Mr. Pandey. That is by other court.
That by
lordship.
Because previously this matter was before Justice
Exactly.
Yes.
But then this court is basically doubting the maintainability of 227. We do not want to complicate things. We do not want to interfere with the jurisdiction validly exercised by some authority.
Right.
This exercise may have caused trouble to you. It might have caused problem to you. But then you have solution in there. Not under 227. Now, what is your prayer here in 227 application?
Well, for the setting aside of that order.
The entire proceeding, it means. Do you want to say?
No, not the entire proceedings.
How can we set aside then? The 227?
That is why the records were required of this matter. As to what is the nature of the proceedings, we are not even aware.
Record has come, but then that is a question of law.
No,
how can an order passed by a civil court, which apparently doesn't show any overstepping of jurisdiction,
I
can be
appreciate.
interfered with under 227?
The issue here is that I cannot be a party to the district council court. My rights are being decided by the district council.
Understand that?
Yes,
we know that.
Yes.
We know that. So that means any order passed by district council will not have a bearing. If some authority doesn't understand that proposition of law, this will not confer any jurisdiction on this court under 227 to exercise issues. This cannot be a ground. If you say that some law enforcing authority is misinterpreting this order and applying it against you, you have a solution in law, not under Proceedings.
Yes, my lords, I appreciate. As far as the maintainability of the question is concerned, my lords, we'll address that because today only the impleadment application is listed.
Why should we implead somebody when this proceeding apparently is not maintainable?
That is for him to argue because I am.
Who is there? Is he supporting your?
Because he, Power Grid is, I believe, the implementing agency for this
So
project.
he is in with you. He is in.
Yes.
My lord, we are the expert agency implementing the project. The project is on the verge of completion, this particular substation being an exception to it. Now, as per the process,
Mr.
my
Khera,
lord,
you are making this matter unnecessarily complicated. Your solution lies else. You see, it is not here, like somewhere else. Please apply your mind, find it out. I don't think the steps which you have taken is very correct step here.
my lord, my
27 will come
primary-
when there is an abuse of us. Just show us what is wrong with the proceedings, except for implementation of order.
Allow us an
Now,
opportunity.
implementation of the order, the court is nowhere responsible.
Because,
the court is not saying that it should be implemented against you.
Yes, my lords.
Then
what I am saying, my lords, allow us an opportunity to go through the trial court records which have been summoned, my lords.
Please, see, this court,
We will address on the.
this court
I
right now
appreciate
is
your lordship.
not disposing this matter.
Right, my lords.
But then before passing that order of impleadment, this court definitely has some reservation.
Yes,
and
lords.
we'll just, what is a report of service here? What is the service report to Mr. Pandey? What is the last? What is the latest?
He was affected. my lords.
We need to take steps.
I'll take, my lords, because my instructions for service
No
have
step
been
is taken.
initiated. my lords.
Nothing, no office note, nothing is there. Court had issued notice.
Yes, my lords. Court had issued notice.
But then no steps has been taken.
I'll take steps, my lords, because I was under the impression that steps have been taken for effecting the service.
This main case is not there today.
Main
Before
case
us.
is not listed,
In the
my lords.
my lord,
In the miscase.
my lord, if I may, the previous order, the previous order of 2611, it only is expressing its opinion where it's calling for the record of the lower court.
Yes.
And once the records are called, then the matter will be taken up for further hearing.
Just see the first part.
That is how the,
Just see the first part of the order.
my lord. My lord, notice returnable on
Yes.
with
So
1
that
week
is-
after the
once
opening of
notice
the
is
court.
issued, that is your duty. Whether that has been specifically
lord.
held,
Since
take steps or not.
I'll
No,
take
we'll do one thing. We'll keep this matter pending.
Yes, my lords.
Even your application for intervention. See the technical part. You see,
it
until
is
and unless you
my
satisfy
case.
this court will not pass.
Yes, it is not my application for
No,
implement.
227 application.
Yes, my lords.
If your application is not maintainable, the implement also would be.
Yes, my lords. Absolutely.
Yes, in the just in the
My lord,
main case, no order is.
my lord.
Yes, Mr. Khera.
My lord, the matter will be directly affecting me also. I may be given an
We are
opportunity
not passing.
to.
We are not rejecting your application right now. Do not expect this court pass to any interim order in this kind of things. If any order is
My lord.
implemented in a wrong way, no way it can be
My lord.
executed to 227. Your
My lord, my
offense is what this court has understood is that implementation, wrong implementation of that interim order passed by the district council. That is the only.
My lord.
Nothing else.
Right,
My lord.
So,
My lord, my
whether
impleadment may be considered.
that will give rise to entertainment of application under 227 or not, that is what is to be said. Please see it. very
My lord, I may be also
Come
given
back
an
with law
opportunity
until
to.
unless you come back with a definite sort of law.
Willows will make it good how the petition is maintainable in this matter, my lords, because there is something to be said as far as our remedies are concerned in these sort of situations, my lords, where we
See,
cannot be a party to
Mr.
the.
Pandey, the basic civil law is that if a decree is passed against a party who is not a party in a suit, this decree cannot be implemented.
Yes, ma'am.
So the law basically that
Right.
is the basis surrounding which you should make your decision.
Yes, ma'am.
Yes. Just say in the miscase that this is an application for impleadment. That's one number 2. as respondent number, as a respondent in CRP number 28 of 2024. It appears from the record that the respondents in CRP number, the existing respondents in CRP number so and so are yet to be served. Let this application be considered after the existing respondents in CRP number enters appearance before this court. When shall we get it listed? When you are going to take steps in that matter?
Let's be listed after 3 weeks because
List
it will give us sufficient
you,
time.
you just satisfy that part. This is a question of law, Mr.
Yes,
Pandey.
Milords, absolutely. It's a Milords, a pertinent question, Milords, in this matter.
We do
as
not
to-
know, Mr. Pandey. You perhaps will be knowing your case better.
Yes,
but then this is what came to mind of this.
No, Milords, it's a
Let us not keep any doubt. You see, if we basically exercise our jurisdiction right now, it will set up bad precedents.
Yes, Milords, I appreciate that.
Yes.
I appreciate.
Yes, good.
Highly obliged.
Highly obliged, Lordship.
Highly obliged.
Highly obliged.
Hearing item number 2.
Yes, 1 minute, Mr. Pandey. Is any date fixed in that CRP for
No, Milords.
listing?
Because Milords, 3rd was a holiday and therefore there is no date which is showing in that matter.
No, when it is
The
to be-
earlier order had fixed 3rd of February as the next date.
Okay. So what will happen now? Then it should have been listed thereafter.
Yes,
Anyway,
Milord. Yes, Milord.
I do not know. Let us see what happens.
Obliged, Lordship.
Obliged, Lordship.
Sorry.
Yes. What is this? Oh,
Yesterday is not going.
where we got stuck yesterday.
Yesterday, my lord, what happened? I placed a judgment of the coordinate bench, my lord, where it was held that our plea that 60% disability is required.
Yeah, this is a case where disability is not ascertained.
Is not ascertained.
Now, what requires is that, as per the various communication,
My lord.
the petitioners requires to make himself present before the appropriate authority for determination of disability. So you do it.
My lord, that is already been 50% has already been assessed as per their direction, my lord. Yesterday I have pointed out, my lord.
Yes, yes, but then they say that you need to appear before some BSF hospital.
Will appear, my lord. That's
so. If you do not have the objection to that, then we can dispose of in that line, saying that you will appear before the respondent authority for assessment on a particular date, and they should take decision within certain period of time, a fixed period of time.
3 months time.
my lord, 3 months.
This man is 80 years. For assessment, you take 30 days time. That is more than enough. Not 3 months.
Assessment as well as final relief. What if he is entitled to anything? Total 3 months.
You are here in this station. You reside in this.
No, my lord. He is
Then
in
you have to appear before the authority
Gorakhpur.
here over.
Gorakhpur, my lord.
Then where he will appear for assessment, Dr. Mujiga?
My lord, a direction may be given to Assam Rifle to facilitate, my lord, not to travel. So somewhere maybe in UP, some army facility somewhere. my lord.
Your only grievance is that you have not been paid that disability pension.
Disability pension, my lord. The assessment was done at their behest, my lord. At their directions, my lord.
Yes, let the court refresh things.
My lord.
But few dates I'll give, my lord. The factual part. My lord.
Mr. Rajha was referring to some notification yesterday.
My lord, that is at page 44.
To page
44. My lord.
Yes. Just let us go through that. What does it say?
The minimum qualification of 10 years, my lord. That's
been done away.
Done away, my lord.
Yes. This is a minimum service required.
My lord.
They say like if you are disabled during the course of your service, then you will be entitled.
My lord.
Okay. Heard, Mr. Arjun, counsel for the petition, and also Dr. N. Majika. GSJ appearing for the respondents. Stop. Paragraph. By this application, the petitioner has raised his grievance against the respondents. Against non-payment of what do you say? What pension it is?
Invalid
pension.
Disability
by
pension.
the respondents. Stop. The petitioner who was enrolled in the service of the respondent, in the service of the Assam Rifles as a rifleman in the year 1974.
1975.
1975.
On 22 on 22nd
January 1975.
Okay. And what is it? The petitioner? On On, just give on. Give the date, Mr. Jha.
22nd January 1975, ma'am.
Comma. Was where is your date of?
It's 9/2/1978, madam.
Discharge, my lord.
Yes, date of discharge.
9/2/1978.
Was discharged from service. On discharge from service on account of disability. The reason for discharge is invalid pension.
Invalid pension.
Discharge on invalid pension. Is this the correct way to say it, Dr. Mojika?
No, madam.
Discharge on invalid pension.
That's presumption that medical pension, my lord. Disability.
We do one thing. What we said?
So discharge by invalid certificate, madam.
Just what we said? The
Discharge certificate.
comma was boarded out of service. Was boarded out of service on which date?
On 20th January 1978.
20th January 19.
It was not correct. 9th February 1978.
Provide discharge certificate dated it's not discernible from here. It's very difficult. What is the date of the discharge certificate?
Discharge certificate date is, my lord.
My lord, date of discharge is mentioned, my lord, at the 4th page of the certificate, my lord. 9th February 1978.
At the 4th page. By if we count the reverse side also.
My lord, my friend is not even paginated my copy, my lord. Even this is
the number is there, then where is the date?
Date of enrollment, date of discharge is mentioned, my lord, in one of the pages.
What is the page, Mr. Jha?
My lord, it's at page, my lord.
Page 36.
Page 36, column 2, my lord. Date of discharge.
This is 9/2/1978.
My lord.
So not the date which you say. The date of the date of January which you have just said just not.
That's not correct, my lord.
And what is the date of the certificate? When the certificate is issued.
It is on the next page, 22 January 1978. Just one page after that one.
Yes. Yes. What we said just. Date just tell us the date. What is the date you said? No. Just a minute. Boarded out service with effect from 9/2/1978. By discharge certificate dated 22nd January 1978. Is it all right?
Yes.
Just write the date carefully. You will not be able to find it out from later. Just tell, just read the thing. Just we have lost the thing. The grievance of the petitioner before this court is that, in spite of his discharge on instead of discharge, he has not been paid. Instead of discharge, he has not been paid. His invalid pension.
Invalid and disability pension.
Invalid and disability pension. As per the as per law.
As per rules and office memorandums issued.
Okay. As per the rules and the related office memorandum. Stop. The petitioner contended that consequent to his retirement, consequent to his discharge from service, he has approached the respondent authority several times. But till date, nothing material has been done in the matter. Stop. Having no other alternative, the petitioner has approached this court for a direction to be issued to the respondents for grant and release of disability pension as admissible. Stop paragraph. Mr. Jha, where is that letter by which
My
you
lord,
have been asked?
page 60, my lord.
Which number?
15.
Page 60. Yes. Paragraph. The learned counsel for the petitioner, by drawing attention of this court to a communication dated 2nd July 2021, submitted that the petitioner was directed to get his percentage of disability assessed by a district government hospital and submit the report to the office of the DG Air, Shillong.
this was in response to our petitioner's representation, my lord. That is at page 57, my lord.
It's all right. We are saying that we are drawing attention to the letter. The letter has directed you to.
My lord.
Now, see, Mr. Jha, thereafter you have written a letter also.
My lord.
The next page.
My lord.
Where you yourself offered to be examined by their doctor, isn't it?
My lord, that's. I am ready, my lord. If the disability is not there, my lord, why I should?
You see, it is there. You have said that is in case you are satisfied, call me and get examined in your hospital or any hospital you like. Isn't it? So you have offered.
My lord.
Okay. It is a submission of the learned counsel that the petitioner, petitioner that as per the requirement, as per the above requirement, comma, the petitioner got himself physically assessed and his disablement was assessed at 50%. Stop. However, in spite of the assessment, the the assessment by assessment, comma, by letter dated 14 December 2021, the petitioner was recommended to be referred to BSF hospital, or CH is what? Civil hospital?
No, my lord. It's composite hospital.
BSF composite hospital, Shillong Port. Obtaining the remarks of the, what is that? Sarge special informs for obtaining the remarks of the, yes, just see, come to page 63, see paragraph 4.
Surgical specialist, my lord. SUG is
Remarks of the surgical specialist.
Surgical specialist.
In forms of the Central Civil Services. Extraordinary pension rules. Okay. In forms of the Central Civil Services extraordinary pension rules. Okay. The starting word of all this things will be capital. All these things. Central Civil. Stop. Step. It is a submission of the learned counsel to petitioner that, in spite of petitioner making himself available for fulfillment of all the formalities, the respondent authorities have till date have not come forward to do the needful as required by the communication dated 14 December 2021. The learned counsel therefore contends that necessary direction be issued to the respondent to complete the requirement that may be necessary for grant of invalid and invalid and disablement
disability pension.
Disability pension.
But it will be entitled to only one pension, my lord. Because all throughout the correspondence is only disability pension, my lord.
That's okay. Your recording is a submission. Okay. Stop. Dr. Mojika, on the other hand, submits that petitioner has approved this court after a huge delay.
44 years.
After a huge delay, and that is precisely the reason why the petitioner case could not be proceeded. Stop. It is also submission of the learned DSGI that in absence of any determinative factor with regard to the percentage of permanent disability of the petitioner, no order as to the entitlement of the petitioner can be passed by the department. He therefore submits that the petitioner shall make himself available before the concerned authority of the department and get himself assessed in order to justify his claim for entitlement of pension. Is that all right? Well, stop. Give a paragraph. A careful scrutiny of the materials of record and the submissions advanced by the learned counsel for the petitioner. Learned counsel appearing for the parties make it amply clear that pursuant to the submission of the representation by the petitioner was asked to submit a report from the district government hospital for with regard to the assessment of percentage of disability. Which was done by the petitioner. Stop. The petitioner was also referred to the BSF. What did you say?
Composite hospital.
Composite hospital, Shillong, for obtaining necessary remarks in that regard. However, in spite of petitioner making himself available, offering himself to make, instead of petitioner offering himself to be present before the respondent authority, nothing has been done in this regard. Stop. In view of the above, at this juncture, it is deemed fit and appropriate to dispose of this writ petition with the direction do you have to refer the decision of justice? Thank you.
Yes.
But it may not be necessary, my lord.
They're not only, my lord,
only for payment, my lord. The payment will.
Just a minute. Do not give that. Do not give that. It is there already. Justice, thank you. Decision. Just please wait. During the course of the hearing, a copy of the judgment and order dated 12/9/2024 passed in WPC number 341 of 2022, passed by a coordinate bench of this court, was placed before this court, wherein in a similar situation, wherein in a more or less identical situation, the court, by relying on the proposition of law
Page 2,
reported in 2015 within bracket 4 GLT within bracket ML 5 has granted relief of disability pension to the petitioner therein. Stop. Now we give paragraph. Stop. In view of the above, this writ petition, the instant writ petition is disposed of with a direction to the respondent to complete the formalities, complete the requirement and formalities of assessment of disability of the petitioner within a period of 2 months, 1 month from today, and complete the entire exercise of determination of entitlement of the petitioner within a period of 1 month thereafter. 1 month for this thing and 1 month for this is enough.
But I'm praying for 2 months. Some procedural things are there.
Okay, assessment you can do it within 1 month.
Physical
assessment
subject to his because he has to come from Gorakhpur. That is
will
also
pass that order. Will pass it. You'll be able to make yourself available before them within 1 month.
My lord, if that be so, tomorrow, if because the petitioner
He's
is,
ready, he's ready.
my lord, petitioner is ready for the.
Yes, any day you can make yourself ready.
My lord.
So what we said, and the last part. Mhm. 2 months thereafter. So see, stop. It is made clear that the petitioner shall make himself available before the appropriate authority as per the direction of the respondent without default.
My lord, and the delay should not be there, my lord, by them.
In the event if the petitioner defaults in appearance, the time stipulated herein will stand extended. In accordance,
accordingly.
Accordingly. Stop. Yes.
My lord, the delay should not be from their side, my lord.
That is already you have given them time.
My lord, and entire exercise, my lord, even
That
the
is
payment.
already come.
That we have already.
But
See, 1 month, within 1 month, you'll be appearing for that physical assessment or whatever they say, and thereafter within 2 months they pass the order. So altogether 3 months,
including payment of the if it.
That is the entitlement.
My lord, my lord.
But only one observation will require, my
Yes.
lord. In the earlier judgment, the reliance on Tarsim that he'll be entitled to areas only for 3 years from the date of filing of report.
Okay.
In view
Yes.
that
Stop. Since the petitioner has approached this court after a considerable period of delay, as pointed out by the learned DSGA, the what shall we say, disability pension or what?
Disability pension.
The benefits of pension as
No,
as determined by the respondent shall commence. We are using the exact words what is in use.
Right.
Shall commence from 3 years before filing of this instant writ petition. Stop. You can say that thing to make it more clear. Needless to add that the respondent shall. Oh, that is already there. This is already there. The computation of the pension payable. The computation of pension payable along with arrears therein be calculated by the respondent within the aforesaid total period of 3 years.
3 months.
Now you'll have to
3 months, man, not 3
3
years.
months within a period of 3 months. That they will correct it automatically. From today or from the day on which?
Copy of the order is furnished.
So you'll have to furnish a copy of the order.
My lord, they have to fix. My lord, they can communicate to me also. Or later when that
You
board.
do it, Mr. Jha, with the proper thing. Keep the thing. If they do not act, then you can.
My lord.
Within period of what you said within no, from the date on which a copy of this order is furnished to the concerned authority by the petitioner. Then you say with the above, this writ petition stands disposed of. No order as to cost. That's all right. There may be bit correction here there.
Daily causeless hearing, item number 4.
Yes.
Please, Your Lordship. Your Lordship, for this matter, the similar matter is pending before the Honorable Supreme Court, and it's likely to be listed on the last week of March.
What is this matter about, Dr. Mojigan? This is
a pay commission, the revision of pay, madam. Fifth pay commission.
So this will be totally dependent on the outcome of the apex pay commission implementation. Of
Similar orders were passed by a single judge of the Honorable Court. Then we preferred appeal before division bench, and now the notice has been issued by Supreme Court, madam.
So,
but only because there are.
You have failed before division bench. Now you have approached the Supreme Court.
Now what has happened, my lord? Because there are 200, 300 respondents of them, my lord.
So you want to travel.
Notice is not complete, my lord. Every day it is listed. Some respondents are not served. Something like that is happening.
It is submitted by the parties that the matter pending before the apex court having hearing in the present case is yet to be disposed of. In view of the submission, this matter after
8
6
weeks. 8 weeks, Your Honor, or Your
8 weeks.
Lordship.
8 weeks. After 8 weeks.
Obliged, Your Lordship.
Item number 13.
Yes.
May I please, Your Lordship? Lordship, the petitioner herein was deprived of the arrear of pension, Your Lordship, that he was supposed to receive. And during the pendency of the instant rate petition, Your Lordship, the petitioner was paid some amount, Your Lordship, out of which we have considered. Although we were disputing with regard to the amount initially, the amount that we claimed was 3,78,645, out of which, Your Lordship, during the pendency of the writ petition, Lordship, the respondent has paid us an amount of 1,93,000.
Yes, all right. Then yes, just tell us.
So we conceded to that amount, Your Lordship.
So
now the only left is that, Your Lordship, we were claiming an interest to that delayed amount, Lordship. Apart from that, the rest of the amount, whatever the dispute was there, we have conceded to that amount.
Yeah, the amount which has been given.
Yes, Your Lordship. We are satisfied with that.
Totally the amount of pension.
Yes, Your Lordship.
So for delayed payment, they have not given you any interest.
Nothing, Lordship.
And what is the delay? What is the period of delay?
Delay was, Lordship, right from 2012.
Now, what is as per your calculation? How much it will come? Now, Mr. Devnath, why don't you pay? See, now so far as the right of the person is concerned,
Your Lordship, here
that got settled, and they are ready to come down from the amount of 3 lakh something to 1 lakh, whatever you have paid.
No, Your
Now,
Lordship,
only thing is that you have to pay the
Your
interest.
Lordship, what's happened in this case? Earlier there was litigation, and after that, Your Lordship, this order was passed on 22nd April 2013. Not only the petitioner, including others, based on the court judgment of the Honorable Court. So, Your Lordship, accordingly, his claim was
Based on a judgment of the court.
Yes, Your Lordship.
So that judgment did not say anything about the interest.
No, Your Lordship. So, what's happened? Not only the petitioner, including others, all has been considered and make payment. And as regard to the petitioner claim, Your Lordship, his claim supposed to be amount of this 5,15,477. It is in my affidavit is given page 25. So, Your Lordship, he was paid already 3,18,784. and thereafter after this honorable court has passed the order, then it has been recalculated, and after this amount has come out 1,96,693, and in between when this calculation is going on, by this time he has preferred the writ petition. So when this writ petition is pending, still when this calculations come up, and then we make payment.
So according to you, he is not entitled to interest.
Yes, yes. So what's the entitled amount? Not only to him, including others. And the here the statement of the others.
What is the prayer in your writ petition? Let us come to the prayer. One of you can go. One of you can go just. May have to correct that order and all.
Lordship, prayer number 7. Issue direction to the respondent number 3 to pay the arrear of pension from February 2012 to April 2013 amounting to rupees 3,78,645.
So there is no prayer for interest.
Your Lordship.
Then now, if you are considering the so far as the amount which you have received, if you are satisfied with that, then the prayer of interest is not here. Your prayer is limited to that 3,78,000.
Yes, Lord. Yes, Lord.
And now you said that because you have received something, okay, you are coming down. That is okay. Matter is over. Then allow it to rest. If you feel that you have a claim for interest, you can write to them. Write it.
But during my previous representation filed before the respondent, Your Lordship, initially what they say that the entire service records were not with them. All these days till the time of filing of this instant writ, they say that the service records of the petitioners were not with them. So the moment I filed this instant writ petition, Your Lordship, they started making payment of that due.
But that is all right. But then see, like say, so far as you see, why? See, there is no say like use digging all those things.
Yes,
because once you have submitted, that at least okay, you are happy with whatever amount is given. But then only your claim right now remains with interest. But then writ petition, there is no prayer for payment of interest. So we'll close on with the basis of this. Where is that order by which you have been paid? Have you
in the affidavit,
Your Lordship? This is my annexures 1, page 18.
Page
18.
18 of your
my affidavit.
Affidavit.
This is the order for all the incumbent who are entitled as per the order of the court, and then particular.
No, when did you receive, Mr. Joshi? When did you receive the thing? When did you receive the amount which you said 1,90,000 thing? Where is that?
96,000 I have received on sir 12 Lordship 12/8.
Where is that? Where is that? Where?
Page 28 of the affidavit, Lordship. Next after
affidavit of
by the respondent, Lordship.
Affidavit in opposition.
Yes, Your Lordship. 28 page. They have transferred it to my account, Lordship. So
just a
account for. The amount is 1,96,693.
Yes.
And the date of transfer is
12/8/2022. On the top, isn't it?
Yes, sir. Yes.
at learned counsel for the parties. Stop. Had learned counsel Mr. Swans, Mr. Joshi, learned counsel for the petitioner, and Mr. R. Devnath, learned CGC, appearing for the respondent. Then give a paragraph. Then you say the petitioner who was serving in Assam Rifles has filed this writ petition claiming arrear of pension from the respondent amounting to rupees 3,78,645, comma, which according to the petitioner was lawfully due to him as arrear pension. Paragraph. The learned counsel for the petitioner submitted that consequent to the filing of the writ petition, comma, the respondent herein has the respondents herein have transmitted an amount of rupees 1,96,693 to his bank account on 12/8/2022 as being the arrear of pension due to the petitioner. Stop. The learned counsel submits that though petitioner has made a claim of rupees 3,70,000 something, what you have written before, okay, in the writ petition, comma, the petitioner at present is happy and satisfied to receive the amount of 1,96,693 which has been paid by the respondent, which is by the consent authority of the respondent. the Learned Counsel submits that though petitioner would not like to dispute the amount of arrear of pension anymore, he has a right to claim interest on the amount for delayed payment. It is the submission of the no, just you just say, do not say it is, don't say it. You say that the Learned Counsel submits that this writ petition may be closed as it fluctuates with the liberty. Do not say that. The Learned Counsel, just cancel that slide. The Learned Counsel please. Learned Counsel submits that though that since the petitioner, Learned Counsel submits that since the petitioner has not just what is the last line before that? The last line, he has a right to claim interest for delayed payment. Okay, for delayed payment, isn't it? Yes, stop, give a stop. The Learned Counsel submits that since the petitioner has not made any specific prayer for grant of interest in the present writ petition, this writ petition may be closed with the liberty to the petitioner to approach the respondent authority for payment of interest.
You will see here in this case, the petitioner was retired on compulsory retirement, and after this filing this
We
case,
have seen that. See, Mr. Devnath, we are not passing any direction. This is his submission. We will only keep that liberty. There is no problem. He approaches you. It is up to you, isn't it? Okay. So you should not object. You should not have any objection with regard to this. Is a quite formal thing.
just
no. We have seen. Yes. See that this compulsory retirement. Yes. It was converted, and subsequently that benefit was extended, isn't it? We have seen that part. So we are not going into all those things. It's not needed. We'll just say we will have a liberty to it. So I think for that you will not have. Yes. The liberty to approach the for the payment of interest. Give paragraph in view of the above submission, this writ petition stands closed as infructuous with the liberty to the petitioner to approach the respondent authority for grant of interest as admissible. Writ petition stands disposed of. Deeply applies.
Item number 18.
Yes.
I may be given the right to reply on the next day, that is next week, Your Lordship.
Don't do that. We'll do it on the same day. This court has a very, like weak memory. You see, the water chips and all this, the memory is already exhausted. So nothing remains there. It gets discharged very fast.
Monday or Tuesday, I'll be any day, Monday or Tuesday.
Any objection with regard to his grant of prayer of adjournment?
No.
Then we'll do it on the same day. You see, it is not that you just tell us when you'll be ready, inform him, then we'll have it.
Anyway, when
See, Mr. Abraham, one thing is that if he dispose of a matter immediately after hearing, that helps the court.
Right.
Otherwise, it becomes difficult. See, if we have the able assistance of the counsel, this court also can dispose of matters. That's the main.
It is no factual part, it becomes easier.
So that is what. So whenever you're ready, see, doing piecemeal will be a problem. If you have to reply on the other day, the next day, this court will forget what Dr. Mojiga had submitted. So we'll have it whenever you want.
On the next day, let us dispose this matter.
What is the matter about Dr. Mojiga?
Madam, this is PC Act matter, my lord. Now
you have come against
an order
of discharge.
No, my lord. We have come against an order whereby the Ministry of Home Affairs has directed permission was taken for tracking his telephone, my lord, tapping his telephone. Yes. Now these are our case is that this is a privileged communication, my lord, which cannot be disclosed, my lord.
Okay, so there is a direction by the court to disclose that.
And there is a stay on this, my lord.
The entire proceeding has been stayed by this honorable court.
No, because if it is dependent on that thing, then definitely. If it's a vital issue, then definitely.
It's a vital issue.
You should be happy with that.
Yeah.
At least so far as the stay is concerned. How many respondents are there?
Only one.
Only one.
Only one respondent, yes, Lordship.
We come after 2 or 3 weeks, man. The next day.
After 2 weeks.
2 or 3 weeks.
2 weeks.
3 weeks.
So we'll go as a joint request.
Yes, Lord.
At the joint request made with the parties, this matter after 3 weeks. The issue is quite interesting. Now, I think the privilege communication. There's a bar in the evidence.
There's a bar in the evidence. Even under the Telegraph Act, there are provisions, my lord.
So the court below has not dealt with that those provisions.
Court has said that we are submitted to the court. We will not disclose, or we will see whether to disclose it to the party.
Then the very purpose of law gets defeated. Then it will never remain privileged. If we have to see and determine my things to decide whether it is a privilege or not, then what? That becomes exposed only. Interesting. Probably, I think there is a direction. There is some direction to the apex court. I think that court has the power to do that also.
Yes, sir.
Isn't it?
Yes. In fact, we are relying on one Delhi High Court decision, my lord, which said no, it can be done. Which is absolutely privileged document.
And that order still holds good. The Delhi High Court judgment. You have the knowledge about the Delhi High Court.
We managed that order in the petition itself.
You have the knowledge of the Delhi High Court.
Yes, Your Lordship, and we also have some other citations.
Definitely. You will tell us which way it's different. All right. Thank you.